Well, good evening and welcome everybody who's here in person, and also welcome everybody who is watching this online. Waiting outside and hearing the noise level in here, we hoped we wouldn't be intruding when we came to join you. Let me introduce the two people who are here with me. On my right, Professor Dapo Akande, who is the Titular Professor of Public International Law at Oxford, a Fellow of All Souls, and the Co-Director of the Oxford Institute for Ethics, Law and Armed Conflict. He's a member of the United Nations International Law Commission and a barrister at Essex Court Chambers. He's held visiting professorships in the US, Europe and Australia, including at Yale Law School and University of Melbourne Law School. He's also currently the UK's candidate for election to the International Court of Justice for the term 2027 to 2036. On my left, Lord Lloyd-Jones, Justice of the Supreme Court since 2017, previously a judge in England and Wales and chairman of the Law Commission. He also has a long-standing interest in public international law, which he taught at Cambridge University when he was a fellow of Downing College for 16 years. And it's also a subject in which he practiced at the bar. The way we're proposing to proceed is that I'm going to get the ball rolling by putting some questions to Professor Akande and Lord Lloyd-Jones, and hopefully they will then run with the ball. And if we proceed in that way, we'll see how it goes. But I'm thinking we might do that for something like 45 minutes, and then allow the last 15, 20 minutes for questions from the audience. So let me begin. When I was an undergraduate studying law 50 years ago, public international law was not a subject which most students studied, as it wasn't perceived to be relevant to legal practice unless you were intending to work for the Foreign Office or for an international organization. The situation seems to me to be very different today, and this court certainly deals with questions of international law quite regularly. So I've got two questions to ask you. The first is, what's your assessment of the change in the relationship between international law and national law? And secondly, what factors do you think have led to this change? For example, is it the impact of the ECHR and the approach adopted by the European Court of Human Rights? Or is it a wider change in the nature of international law that lies behind this? Or rather a number of different factors operating together? So let me begin with you, Dapo.
Thank you very much, Lord Reid. Let me begin by thanking you and Lord Lloyd-Jones and all those at the court who've been involved in organizing this event. It's a pleasure to be here, and it's great to see so many people here. Particularly appropriate that we be talking about the relationship between international law and national law to lead off this conversation here at the Supreme Court. I think the court put out a publication last year in which it included the cases that this court has dealt with over the last, I think at that time, 15 years, raising questions of international law. And it's testament, actually, the length of the publication is testament to the change that you've just been talking about, the fact that international law is now regularly applied in the domestic courts in this country. And not only are parties willing to raise these issues, the judges are also willing to engage with these issues. There are two cases that I often think of as being emblematic of this change, this willingness of domestic courts in this country to engage with questions of international law. The first one is the decision of the House of Lords in one of the Tin Council cases in 1986. I see some people in the room who were involved in the Tin Council cases. For those of you who may not know very much about those cases, it was about the liability of the International Tin Council, an organization that was...
Are you having difficulty hearing us?
Speak into the mic. Okay.
Right.
I will move forward.
Thank you.
And hopefully this will be better. I was saying that there are two cases which I think are emblematic of this change in the attitude of domestic courts in this country and the willingness to apply international law. First, the International Tin Council cases, which I know Jeremy was involved in, 1986. International Tin Council, an international organization set up to help to regulate the price of tin. It bought tin, and the price of tin fell. It continued to buy. The price of tin continued to fall. And the member states of the International Tin Council were sued, and questions arose as to their liability for the conduct of the organization. And there were questions around whether, under international law, members of an international organization had this liability for the conduct of an international organization that was a separate legal person. And in the decision of the House of Lords, Lord Templeman, who gave one of the lead judgments, he began his judgment by saying, "My lords, this case raises the short question of the construction of a statutory instrument." And he had been faced with all of these arguments around international law, but I think the opening sentence indicated that he didn't find those arguments particularly helpful. He then ended his judgment. The final paragraph says, to decide this, in the discussion of this short question, we have had locked in battle, I think he said 24 counsel assisted by a battery of solicitors with over 200 bundles who have addressed us for 26 days. He then went on to recommend that in future, the House of Lords limit the amount of time that is permitted for oral argument before the House of Lords. And that was a decision where I think, at least from his perspective, he didn't find international law to be particularly relevant. It was all about the domestic implementation of international law in this statutory instrument. 20 years later, we had, in the Al-Jeddah case, a case dealing with the detention of an individual in Iraq. Questions arose as to the application of a Security Council resolution within UK domestic law. And what's fascinating is that the House of Lords gave effect to this Security Council resolution without even explaining the basis upon which a Security Council resolution applies as a matter of English law. And just 20 years apart, and I think those two cases illustrate something that's very significant, which I think the first answer to your question, not necessarily the biggest issue, but I think the attitude of judges changed significantly over that period. I think Lord Bingham had given a talk at some point in that period which is titled something like "There's a World Out There." But in addition to the attitude of judges in this country changing, I think actually also there's been a change in the nature of international law. You look at the first edition of Oppenheim's International Law, and it begins by saying international law is the law that applies to the relationship between states, full stop. But of course today that is true, but that is only partly true. International law is not just the law that applies to the relations between states. It applies to the relationship between states and private entities, states and individuals, states and corporations. And I think there's been a change in the nature of what international law regulates. Much of international law today is what one might describe as inward-looking. The very point of many rules of international law today is to regulate how states behave domestically, to regulate their own internal, to regulate affairs internally. And to that extent, those rules are intended to apply domestically. And so I think judges have found it useful and important to apply those rules of international law that are in fact intended to apply domestically. And then, of course, the world is more global. The world is more connected. There are more occasions to apply rules of international law. And so I think it's a combination of these things that has led to a greater willingness of judges to apply international law domestically. Of course, we have had, as you indicate, the domestic application of the European Court of Human Rights with the Human Rights Act, which has led to some familiarity amongst judges and counsel as well with issues of international law, but which has also meant that actually in the interpretation of that convention, account has to be taken of other rules of international law. So I think it's a combination of these issues.
David.
Thank you. Well, can I begin by saying that I'm delighted that this seminar is taking place, and it's a particular pleasure to welcome Dapo to the Supreme Court. Speaking from the angle of a national Supreme Court, I think Robert's certainly right in identifying a major change. Public international law is now very frequently the subject of litigation in this jurisdiction and in this court. It's encountered far more frequently than it was, say, 50 years ago. It's no longer a quaint, specialized subject, it's mainstream. And as a result, a command of public international law and of domestic foreign relations law is certainly required of the judges, and it has become an indispensable element in the equipment of every public lawyer practicing in this jurisdiction. I think there are several reasons for the change, and they've been touched on already by Dapo. There's been a major change in the nature of international law itself. Secondly, in this jurisdiction, a major change has been brought about by the implementation of ECHR rights through the Human Rights Act. That has certainly played a major part. It, of course, involves the interpretation of that convention. It involves questions of international law which are relevant to its interpretation. But it's made, in addition, issues justiciable before the courts which might not otherwise have been justiciable, matter touched on by Lady Hale in the Pretty case, for example. And we've also seen a massive expansion of the scope of the European Convention on Human Rights. The jurisdiction, the scope of application of the Convention is now massive. We've seen it extended, for example, to armed conflict. The fact that territory is under the control of a contracting state necessarily brings into play the Convention itself. More recently, we've seen, since Bankovic has been abandoned apparently in Al-Skani, we've seen a further very profound extension of the scope of ECHR in that control over an individual is now taken to be a basis of jurisdiction. There's certainly some uncertainty as to precisely what that means. It may be, as Lord Sumption suggested in one case, that any use of force by a contracting state against an individual is now brought within the scope of the Convention. So it seems clear that amidst the clash of arms, the European Convention on Human Rights is not silent, and as a result, this court, for example, has had to address such issues in Al-Wahid. Really difficult issues arose in relation to the rights of detention of individuals in armed conflict. The Strasbourg court itself had to modify the scope of Article 5 in the Hassan case. This court in Al-Wahid had to address the question of the powers of arrest and detention, not in a case of international armed conflict, as was the subject of Hassan, but in the case of non-international armed conflict. And that led to a dissenting judgment from Lord Reed, addressing the whole question of whether a right of detention arose either in customary international law or by treaty. Who would have thought 50 years ago that such issues might be considered by a national court? There's also been a change in judicial attitudes. Judges in the United Kingdom have been increasingly willing to address and to investigate the conduct of foreign states and issues of public international law where appropriate. Judges in this country are no longer as deferential as they were to the conduct of foreign states and governments. But perhaps the most important factor, and I think it is the main explanation for the increase in the number of cases before national courts raising points of public international law, is the nature of the change which has occurred in public international law itself. The notion of public international law as a system of law merely regulating the conduct of states on the international plane has now been discarded, and in its place has emerged a system which more frequently addresses and governs issues affecting individuals. And this includes the regulation of human rights by international law, a system of which individuals are rightly considered to be subjects. States now accept that international law imposes minimum standards for the content of a state's domestic law. This court, in Belhadge and Straw in 2017, it was a case concerning alleged unlawful rendition in which the United Kingdom was said to be complicit. This court explained in that case that since the Second World War there's been a considerable expansion in the range of matters with which international law is concerned, which now extends to many aspects of the relations between states on the one hand and their subjects or residents on the other. It's not limited to the protection of international human rights. International law increasingly places limits on the permissible content of municipal law and on the means available to states for achieving even their legitimate policy objectives. So, international law and domestic systems of law are no longer operating in wholly discrete spheres totally remote from one another. Although the systems remain different in many ways in nature, much of the subject matter which they seek to regulate is appropriate for regulation both by international law and by domestic systems of law. And in the light of this growing overlap of application and subject matter, it's not surprising that issues of international law are today encountered far more frequently before courts in this jurisdiction.
Can I pursue a point which you touched on? As you said a moment ago, municipal courts now find themselves having to consider the conduct of foreign states and its compliance with international law far more frequently than they ever would have done in the past. And you gave the example of the Belhadge case where the court was considering foreign act of state in the context of alleged unlawful rendition and torture. We've also had a number of cases here about diplomatic immunity in relation to human trafficking and state immunity in relation to employment disputes, even duress in relation to the international relations between Russia and Ukraine. And that, one might say, is these are rather special cases perhaps, but every day courts and tribunals dealing with asylum and immigration cases are considering, in the context of applications to deport people, whether foreign states have complied with their human rights obligations or are going to. They consider, in the context of extradition, whether the judiciary of foreign states are independent and impartial or not. They consider whether states, for example, in the Rwanda case, we considered whether a state had complied with its obligation of non-refoulement under the Refugee Convention. So there's nothing unusual about this kind of exercise being carried out nowadays. So, again, I've got two questions. Is there has there been a significant change, do you think, in the approach taken to concepts such as comity, justiciability, act of state, and more generally in the attitude shown by municipal courts towards foreign states? And if there has been such a change, does it cause you concern? Dapo.
So I think you are right that there are more occasions for domestic courts, and courts in this country in particular, to consider the conduct of foreign states, and the attitude of the courts seem to have changed. You know, the act of state doctrine, or the foreign act of state doctrine to be more precise, is one which requires the court not to adjudicate on the legality of the conduct of a foreign state, and that the application of that seems to have waned, in the sense that courts in this country have been much more willing to engage in that adjudication and to find exceptions to the rule, or even to redefine it. Likewise, in relation to non-justiciability, courts have been much more circumscribed in thinking about the circumstances in which courts in this country, ought to refrain from adjudicating on the relations between foreign governments. But I think if one takes a step back and looks at it actually from the perspective of international law, in other words, what might international law require or not require, I think one can distinguish two types of situations. So the first sort of case is a case where, from the perspective of international law itself either permits or sometimes even requires domestic courts to assess and to adjudicate on the legality of actions of foreign governments. So cases where international law has a rule that to apply that rule, actually domestic courts will have to adjudicate on the legality of the conduct of foreign states. So if one thinks, for example, about the case Kuwait Airways and Iraqi Airways arising out of the Gulf War 1990, and the question there was whether or not these planes that had belonged to Kuwait Airways, whether these planes should now be treated as the property of Iraq Airways, and the House of Lords decided that it was entitled to disregard the legislation of Iraq that purported to transfer these planes to Kuwait Airways. If one looks at that from the perspective of international law, one would say, well, there are at least two rules of international law in operation here. So one, you have a United Nations Security Council resolution that actually requires states not to recognize the Iraqi annexation of Kuwait, and also requires states not to recognize the consequences. And perhaps even more broadly, you have a rule of international law, a broader rule of international law, that provides that states should not actually recognize an unlawful use of force. So independent of the Security Council resolution, states should not recognize an unlawful use of force and shouldn't give effect to the consequences. So from the perspective of international law, it would seem entirely appropriate that a court in this country actually, as part of the UK, fulfills that obligation of not recognizing something that international law requires the state not to recognize. You have other cases where a rule of international law similarly requires a domestic court to adjudicate on the legality of the actions of another state. So, for example, I think you spoke about evidence obtained by torture. The Torture Convention requires states not to permit the use of evidence obtained by torture. Torture under the Torture Convention is committed by officials or is done in an official capacity. And so to implement that rule of the Torture Convention, a domestic court actually has to make a decision as to whether torture has taken place. And so from the perspective of international law, it's entirely right that the state make a decision as to whether or not there has been torture, and that might implicate other states. or the asylum cases you talk about. So whether or not a state, whether a country is a safe country to which an individual may be sent, again, international law requires a state not to send an individual to a country where, if it is the case that that individual might be sent by the state to the home state in breach of the Refugee Convention. So there are a number of cases where, from the perspective of international law, one would say that actually international law itself requires a domestic court to make this adjudication, or certainly permits it. And I have no difficulty with those kinds of cases. I think this is, courts doing that is consonant with what international law requires. But having said that, I think there are other cases where a court does have a choice. International law does not itself require or permit adjudication. And then the question that arises is whether, what attitude should the court take? And though it's my view that the foreign actor state doctrine is not one which is required by international law, I think it is underpinned to some extent by what one might call international law considerations, in the sense that as a general matter, states are required to respect the independence of other states, and as a general matter, disputes between states are to be settled on the basis of consensual dispute settlement between those states. So even though international law does not directly require the domestic court to refrain from adjudicating on the legality of the conduct of other states, I think a respect for independence and the sovereignty of another state does mean that there are cases where it would be appropriate for domestic courts actually to refrain from adjudicating. And if one thinks particularly of the non-justiciability doctrine, particularly where we are talking about situations where a domestic court might pronounce on a dispute between foreign states, it would be odd if in the International Court of Justice, the International Court is unable to make certain determinations, even with regard to a state that is absent, a state that is not before the court, because that state has not given its consent. It would be odd if the ICJ was required by a rule of international law to so refrain, but a domestic court was not required to so refrain from making pronouncements about disputes between states in cases where the state was not a party. If the state is a party, it would be straightforwardly a question of sovereign immunity. But if the state is not a party, even in the ICJ, there would be occasions where the court would refrain from making that adjudication. So all to say that, on the whole, I'm not concerned that there has been, or that there have been more cases where domestic courts have been willing to adjudicate, and I think that in many cases that is consonant actually with what international law requires. But I do think that international law considerations still underpin a basic foreign actor state rule that requires states to exercise caution in adjudicating on the conduct of foreign states, even when the foreign state is not a party, particularly if the effect of the adjudication by the domestic court is to overturn actually decisions that a state has made within its own territory. I think particularly in those cases, international law would underpin something that's like the foreign actor state doctrine that we have in this country.
David.
Thank you. Well, the answer to your question is that I don't think there's anything to be concerned about. On the contrary, I think the relationship is moving, the relationship between international law and domestic law is moving in the right direction in this jurisdiction. There is an apparent conflict, an apparent contradiction, in that on the one hand we see a much greater willingness on the part of national courts in this jurisdiction to criticize the conduct of foreign states and governments. And at the same time, on the other hand, we're seeing the development of pretty clear notions now of active state and non-justiciability, probably for the first time. So far as the first is concerned, there's been an extraordinary change. You only have to look at cases like Cotronis in 1971, Lord Reed, or Lord Templeman in Williams and Humbert in 1986, cases where an extraordinarily deferential attitude was taken towards the conduct of foreign governments. Positively timid, in my view, that bears no resemblance to what's happening today, and Robert's identified a number of areas, asylum and deportation cases, where courts are daily called upon as part of the process of assessing the risk to individuals to determine whether foreign governments have violated or whether there's a real risk that they might violate human rights standards. And country guidance cases are replete with references to human rights breaches by certain foreign states and governments. And judges are frequently required to rule on whether other states have complied with their obligations of non-refoulement, for example, under international conventions. When you're talking about selection of forum or enforcement of foreign judgments, judges often have to decide issues relating to the independence and integrity of the judiciary of foreign states. And the example that Dapo's raised, a court may have to decide whether evidence is inadmissible because it was obtained by torture carried out by officials of a foreign state in order to determine whether it's admissible. So that's one side of it. On the other hand, we have now a developed principle of act of state and non-justiciability. It's not a real contradiction because of the limits on those principles of non-justiciability and act of state. Dapo's mentioned some of the extensions, some of the exceptions. One of particular importance is that the act of state principle only applies if the challenge is to the validity or the lawfulness of the state's sovereign acts. It has to be part of, that challenge has to be part of the very essence of the subject matter of the action, in the sense that it cannot be resolved without determining it. And as a result, those cases, such as deportation or extradition cases where there's criticism of the conduct of foreign governments, don't fall foul of the rule. They don't offend against notions of act of foreign state. The Supreme Court explained in Belhaj that such cases are not directly concerned with the legality of the conduct of the foreign state. The English court is simply applying its own standards to an exercise of its own jurisdiction. And in this way, the greater willingness of courts in the United Kingdom to investigate the conduct of foreign states can be reconciled with principles of act of state. Those principles, although foreshadowed in the 19th century, only emerged fully in Butes, Gas and Hammer about 50 years ago. And 50 years later, the scope of act of state is being developed and clarified by the court in a series of cases, in Belhaj, in Maduro and Guaido, for example, a case concerning two bodies, both claiming to be the board of the Central Bank of Venezuela and therefore entitled to the gold held in the Bank of England. In that case, the question of the validity of the exercise of the executive power of the president or the person claiming to be the president to appoint the board of the Central Bank of Venezuela was central to the claim. And this court gave effect to that, applied the act of state doctrine, and stated squarely for the first time that there is a principle of act of state which applies to executive acts of a foreign government. Another case which on its face seems a little startling is the Law Debenture Trust against Ukraine, which Robert has mentioned. That case was essentially a dispute between two states, Ukraine and Russia, as to whether a loan had been induced by duress. The case, I should say, was heard before the invasion of Ukraine in 2022. It does seem rather strange that this should be heard by a national court. It was, however, a contractual dispute between a trustee acting on behalf of the Russian Federation and Ukraine. The contract was governed by English law, and there was a jurisdiction clause in favor of the English courts. As a result, the Supreme Court was required to grapple with issues such as the legal personality of sovereign states, their capacity to enter into and avoid contracts, including in particular on grounds of duress exerted by another state, and the authority of those acting on their behalf. And we said that all of those issues were justiciable. The decision did not fall foul of any principle of active state or non-justiciability. We decided that it was necessary to determine at trial whether Russia's threatened use of force amounted to duress of the person or duress of goods, so as to impose what English law would regard as a legitimate pressure on Ukraine to enter into the trust deed. This did not require a ruling on the legality or the validity of the alleged conduct of the Russian Federation under international law, nor did any question arise as to the validity or lawfulness of its conduct in English municipal law. There was a question as to whether the Russian Federation's alleged threats to persons and property rendered the notes voidable under English law by reason of duress, but there could be no objection to the English courts determining that question, where the Russian Federation had arranged that the trust deed should be governed by English law, and there was a jurisdiction clause which permitted the English courts to determine any questions arising. There was, however, in the Lord Depenture case, a further submission. The appeal also required us to consider whether submissions concerning the international law doctrine of countermeasures could be given effect by a national court. And we did draw the line at that. And we said that that was not justiciable. It was not suitable for adjudication by courts in this jurisdiction. For two reasons. First, English law doesn't recognize a defense reflecting the availability of countermeasures in international law. Secondly, the subject matter of such interstate disputes, we said, was inherently unsuitable for adjudication by courts in this jurisdiction. That it was not the function of national courts to arbitrate interstate disputes arising on the international level and governed by international law. And while that second objection, I should say, may be subject to exceptions founded on domestic public policy, it wasn't necessary to address that issue because the first objection was a complete answer. So Ukraine had no arguable defense in these proceedings based on any right it may have in international law to take countermeasures at the international level. So it does seem that a close analysis is required of the particular issues in each case in order that it should be decided whether or not the proceedings fall foul of the active state principle. But when that is carried out, there's no inconsistency in principle between the greater willingness on the part of courts in this jurisdiction to criticize the conduct of foreign governments and the principles of non-justiciability and active state.
I might perhaps comment, if I may say so, that if our case law has clarified the approach taken in English law to active state and justiciability in recent years, that's essentially because the gentleman on my left has been writing all the judgments. And it's been very useful having somebody with real expertise in public international law on the court, which is something for us to bear in mind, I think, in the future. If we have municipal courts considering issues of international law to the extent that we've spoken about, what role do you think municipal courts have in the development of international law? Dapo.
Yeah. No, so looking at this from the perspective of international law, so what role does international law accord actually to decisions of municipal courts? I think one can, in the first topic that one teaches in a course in public international law is the first topic that I teach in a course on public international law is sources of international law. I think some people persist in teaching as the first topic is international law. sort of dispense with that, at least as the first question. I'd proceed straight to the sources of international law. And I think that's where the answer to your question really lies. So what role do domestic court decisions play within the sources of international law? And the sort of straightforward answer that one would give is to say, first of all, much of international law is still to be found in customary international law. And the decisions of domestic courts are actually an aspect of state practice in the same way as acts of the executive and in the same way as legislative acts are state practice. And so insofar as one is trying to form a judgment as to whether or not there is sufficient state practice and opinion juris around the rule of customary international law, it is important to also look at decisions of domestic courts. Of course, one looks at decisions of domestic courts as part of the assessment that one is making as to whether or not there is a general state practice. And that assessment that one is making as to whether or not there's a general state practice is an assessment that one makes, if you like, looking at different countries, but actually also one might make that assessment in terms of what is also happening domestically. So to the extent that the practice of the executive is different from the practice of courts, it is less likely that one comes to the conclusion that there's a general state practice. And so that's important. And there are many areas of international law where that the role of domestic courts is particularly important in making that assessment. So you spoke earlier about decisions of the court on questions of state immunity, even decisions of the court on questions of diplomatic immunity. The judgments of domestic courts are part of state practice. And for example, when the International Court of Justice actually very rarely cites decisions of domestic courts. But in cases concerning immunity, the court has in fact done that. The International Court has looked at decisions of domestic courts as part of its assessment of what customary international law is. Secondly, in that assessment of sources of international law, another source to think about is general principles of law. So I'm a member of the International Law Commission, and we've just been considering this topic, actually, general principles of law as a source of international law. And there, of course, decisions of domestic courts have a particular role because we're looking at principles of law that are applied domestically, but you're making an assessment as to the extent to which they are sufficiently general. But perhaps the most interesting area to think about in terms of the value of the role of domestic courts is, again, sticking with the sources, the role of domestic courts in terms of what the statute of the International Court of Justice describes as subsidiary means for the determination of rules of law. So using decisions of domestic courts as a way of identifying what international law says. And it may well have been the case that in the past, when international law was just about interstate issues, as we were talking about earlier, the occasion to look at decisions of domestic courts for that purpose would have been, shall we say, not extensive. But of course, to the extent that today, much of international law is of the nature that we've just been describing. It's regulating the relationship between states and private parties of different natures. It means that actually the primary place where international law, some rules of international law are being applied is in the domestic sphere. And so that means that actually when one is looking at how does one identify these rules, the first port of call will be looking at what domestic courts do. And I suppose the question then for domestic court judges, I suppose, for you is what is the approach, or what should the approach of the domestic judge be in these kinds of cases? Should the approach of the domestic judge be one where the domestic judge takes on for themselves and actively takes on for themselves the task of actually trying to marshal the evidence and come to conclusions as to what international law says, even though an international court may not have come to that conclusion and the judge actually takes on that task? Or to what extent should the judge the domestic judge, feel that they ought to be sort of following behind rather than taking the lead? And it may well be that the approach of the domestic judge might be different in particular cases. So if we're thinking about, for example, now different area treaty interpretation, if we're thinking about, say, the European Court of Human Rights, where there is the European Convention on Human Rights, where there is a court, I know courts in this country have taken the view that they shouldn't go further than the court necessarily takes, and that may well be appropriate in that context. But there may be other contexts, and in fact it's frequently the case that in other contexts these are questions that will not necessarily come before an international court. And I think it's entirely right for a domestic court judge that has to apply, for whatever reason, a rule of international law, to take that task seriously and to seek to do that. And we've seen that in some cases in this country. I'm thinking about the case dealing with special missions immunity, which was an issue, if you like, of first impression, and where I think it was, can't remember if it was High Court or Divisional Court, but certainly in the Court of Appeal, there was a very rigorous assessment of what customary international law said, assessing the state practice. And I think it's entirely right that the domestic judge doesn't feel inhibited in actually making that judgment for themselves. And then, of course, in international law, we then look at those decisions as examples of places where those rules have been identified, and I think it's entirely appropriate that be so.
David?
Well, two short footnotes from me, if I may, in relation to what Dapo's just said, with which I entirely agree. As to Dapo's first point, I think it's important to emphasize that the relationship between customary international law and domestic law, the common law in this jurisdiction, is a two-way street. It operates in both directions. Decisions of courts in this jurisdiction are one aspect of state practice of the United Kingdom, and as a result can, in these changing circumstances which we've been describing, be increasingly influential in the development of customary international law. But it's necessary to enter an important caveat, and that is that it's not for national courts to make the running or to force the pace in the development of customary international law. It will often be tempting for a national judge to seize an opportunity to say that something emerging practice has become a rule of customary law. I think that's something that has to be resisted. Certainly it should be resisted if its emergence as an established rule has not been accepted by other states. And as Lord Bingham put it in Jones and Saudi Arabia, one swallow does not make a rule of customary international law. We had such a submission in El Ghazouli before this court a few years ago, where the Supreme Court in 2020 unanimously rejected as impossible to accept a submission that there's an emerging norm of customary international law, and that the death penalty as such is a violation of the absolute right against torture and cruel, inhuman, and degrading treatment or punishment, and that a norm against the facilitation of the death penalty follows from that. Nevertheless, subject to this point, judicial decisions in domestic courts are an important evidence of developing state practice and opinio juris. It's true, of course, that judicial decisions are identified in Article 38 of the statute of the ICJ as a subsidiary means for the determination of rules of law. But this is perhaps a reflection of the nature of the judicial function, and there's no difficulty in seeing a subsidiary means for determination of rules of law as being a source of the law, not merely by analogy, but directly. As issues of international law come increasingly to the fore in domestic litigation in this jurisdiction, the potential of national decisions in this regard will also greatly increase. The other footnote concerns the case about special missions, which Dapo mentioned. I wrote the judgment in the divisional court in that case, and I was furious with Mary Arden that she gave permission to appeal I was, however, upheld on every point. We both had the advantage, however, of an article which had been written by Michael Wood, Sir Michael Wood, formerly of the Foreign Office, in which he had surveyed the state practice in relation to it. It was available to the court in a form which can rarely be available, it seemed to me.
Well, thank you both very much. I think it's time to get some audience participation. So can I invite perhaps 2 or 3 questions? Yes, please.